But these days, oh, if we can go back, yeah, these days the legal standard is that the land use decisions must be consistent with provincial policy. That's a stronger, and I would say better legal standard. And it's a standard that applies to all planning authorities in the province, just not just municipalities. I think that's pretty apparent to most folks. So let's move on, Anastasia. So how is provincial policy framed and implemented? Well, as some of you know, the policies themselves are crafted in different ways to achieve different purposes. For example, some policies are permissive, might say something like municipalities may do this or may do that. Other policies are more directive in nature. They may provide more firmer guidance, such as municipalities should do this or should do that. And then we have some policies that are very prescriptive or contain general prohibitions, something like development shall not be permitted in this feature or that feature. And to assist in the interpretation of the different policies, the PPS contains various principles, some of which are depicted on this slide. I won't go through them in any particular detail, but I will say this. Problems can and do occur when two or more provincial policies apply to the same development application or the same situation. You know, for example, the PPS tells us to protect prime agricultural land, but at the same time, the PPS allows aggregate extraction to occur on such lands. You know, that seems to be a fundamental conflict at the land use planning stage, and it's hard to reconcile those two policies. Unfortunately, the policy statement itself doesn't provide a lot of guidance in resolving conflicts like that. I think we'll move to the next one. So with that very brief background in mind, let's turn to the current PPS review. This slide provides the basic information that you'll need if you want to participate in the review. Anastasia will come back to this at the end of her presentation, so I won't spend any particular time on this. But for now, I just want to emphasize or encourage everyone to get involved and to participate in the review. I would encourage all of you to submit comments on the PPS. I can't overemphasize how important it is to get the PPS right. As you know, it's going to be in place. Once it's finalized, it'll be in place for some time. It'll be guiding land use decisions all over the province for years to come, at least until the next review. And so this review matters to all of us. It particularly matters to CELA clients. As you know, CELA represents low-income individuals and vulnerable communities throughout the province. And they often find themselves at the receiving end of noxious land uses that have been approved under the Planning Act. And that is why, from CELA's perspective, the PPS needs to be strengthened and improved. So the current PPS focuses on a few key items. I won't read them all to you, but they're outlined in the first bullet point. I'm going to focus primarily on item B, whether and to what extent the new policies will protect the environment and public safety. I've also listed on the slide the key questions that the government wants stakeholders to answer when they're making submissions on the proposed PPS. For example, do the proposed policies effectively support goals relating to increasing housing supply, creating, maintaining jobs, red tape reduction, while continuing to protect the environment, farmland, and public health and safety? So that seems to me to be the overarching question. And my answer to that question is no. And we'll explain why in a few moments. So the first topic I'm going to deal with are the new PPS policies dealing with the environment and public safety. If you've read the 2019 PPS in whole or in part, you'll see that a lot of the current policies in Section 2 and Section 3 of the PPS are more or less left intact. They're not really going to be changed, which of course begs the question whether to what extent they're adequate as is. I draw no particular comfort from the fact that some of the policies are left unchanged because I think it's debatable whether they're fully effective as currently drafted. So for example, we're still continuing to lose wetlands at an alarming rate, even though we have wetland protection provisions in the PPS right now. And then, of course, some of the new provisions, in my view, will weaken or provide additional loopholes which undermine those current environmental policies. And so my conclusion is that many of the PPS changes that we're going to talk about today actually roll back the protections of the PPS. They don't advance them, they don't enhance them in any particular meaningful way. So this is what the Ontario government is proposing to achieve through the new or amended policies dealing with environmental matters. For example, it's argued that the 2019 PPS, once finalized, will do all these wild and wonderful things that we see in paragraphs A to F, enhanced direction for preparing for the impacts of a changing climate, enhanced stormwater management policies, maintain policies in relation to natural heritage, protect the green belt, and all the rest of it. So I see these as the benchmark for assessing the PPS policies that are now being proposed. I guess the overarching question is whether the new policies will actually achieve these outcomes. And with that in mind, let's take a closer look at some of these proposals. So we're going to deal first with wetlands, but before I begin, I want to preface my remarks by saying that what I've tried to do here and in the following slides is identify the key changes from a public interest perspective and from CELA's experience in land use planning on behalf of our clients over the past, 30, 40, 50 years. So I acknowledge that my list is somewhat subjective. I recognize that some of you in this webinar may have different policies that are of concern for you, or you may have different reasons for being concerned. But these are the ones that jumped out at me as I went through the 2019 PPS. So as I mentioned in the first bullet point, a lot of the existing policies are left intact. Is that good enough? Is the status quo good enough, or does it need improvement? I would say yes. But here, with respect to wetlands, the new PPS is suggesting a new policy that would allow municipalities to choose to protect non-significant wetlands in accordance with guidelines prepared by the province. Well, first of all, I would question why this is even optional, given the historic wetland losses that we've experienced already in this province. I haven't seen the guidelines, so I don't know if they're any good. And the problem that I see most fundamentally is that, if unevaluated wetlands aren't really assessed, they're going to be left to the discretion of local municipalities. I'm quite concerned about what happens if the local municipality does not take any proactive steps to delineate or protect some of these local wetlands, even if they may end up being provincially significant if assessed. So I see that as leftover business, or unfinished business, I should say. We'll go to the next one. The second change that I've flagged involves water and climate change impacts. And again, many of the existing water quality and quantity policies aren't being changed, but the government is proposing a new policy that would require planning authorities to evaluate and prepare for the impacts of a changing climate to water resource systems at the watershed level. Well, I guess it's a good thing that the provincial government is recognizing and defining impacts of changing climate, although it also appears from the definition of impacts of a changing climate that the current government sees opportunities as climate change continues to impact Ontario, north and south. But again, as an implementation issue, I have to question the effectiveness of this high-level direction to planning authorities, especially in light of changes to conservation authorities in terms of their mandate and composition and funding. So it's unclear to me how this new policy is actually going to provide any meaningful direction to planning authorities, or how it's going to make any difference on the ground. So we'll go to the next one. This is a third change that I've flagged pertaining to agricultural lands. And again, the existing agricultural lands are left more or less intact, but that's a concern because, as you know from reading the current PPS, aggregate extraction can be allowed even in prime agricultural areas. So, you know, until that fundamental conflict is resolved, we're still going to have these intractable, you know, land use debates at the local level when the provincial policy on agricultural lands is butting heads up against the preference for aggregate extraction. I also, on this slide, make reference to a new policy aimed at a systems approach to agricultural lands and the agri-food network. I really don't know what any of this is supposed to achieve, but for clarity purposes, the PPS adds a couple of definitions for these two terms. That brings me to the fourth change, and that is the PPS policies that govern aggregate extraction. As most of you know, the current PPS gives aggregate extraction provincial priority. The PPS directs planning authorities to lock up and allow the extraction of aggregate deposits generally. And there's nothing in the new PPS that changes that priority. In fact, to the contrary, the new PPS continues to give preferential treatment to aggregate extraction by allowing pits and quarries outside of the Greenbelt area to be permitted in natural heritage features listed in section 2.1, 0.5, 0.6, 0.7. And stopping right there, I see this as arguably one of the most alarming new proposals in the new PPS, and that's because you'll recall that policy 2.1.5 deals with significant wetlands in certain ecoregions of the province. It also deals with woodlands, valley lands, wildlife habitat, ANSIs, and other natural areas and features. 2.1.6 deals with fish habitat. 2.1.7 deals with endangered or threatened species habitat. And all of those key features are open to aggregate extraction under this new policy, provided, of course, that the proponents' rehabilitation plans can demonstrate no negative impacts in the long term. Again, based on my experience, I draw no particular comfort from that proviso or from that qualification, especially given the rather malleable nature of rehabilitation planning in this province, and the fact that rehabilitation has often been either non-existent or of very poor quality where it's been carried out at all. And that's not just my view, that was the view of the Environmental Commissioner in her 2017 report on the state of aggregate extraction in this province. So I'm not entirely happy with this particular proposal. In fact, we're quite alarmed by it. The second bullet point, I think I'll come back to when I deal with the ARA. The final change I wanted to deal with in the PPS deals with man-made and natural hazards. For example, the new policy simply tells planning authorities to prepare for, to get ready for the impacts of a changing climate that may increase the risks associated with natural hazards, things like flooding and erosion and so forth. And again, I'm not entirely sure that kind of a high-level warning to planning authorities really provides any meaningful planning direction on the ground, but I guess we'll see how that one's actually implemented. I'll skip the last bullet point for now. So let's move on to the Aggregate Resources Act review. So as you know, the Aggregate Resources Act, or ARA as we like to call it, is a regulatory statute. It's not really a planning statute. And the ARA governs aggregate operations in certain areas of the province. I think of it in these terms: where an aggregate operation can be established on the landscape is determined under the Planning Act and the PPS and municipal official plans. But how aggregate operations are conducted is largely determined under the Aggregate Resources Act and the regulations and other environmental laws that may be applicable, things like the Ontario Water Resources Act. And so when the minister or the tribunal are deciding whether or not to refuse or grant an ARA license, the Section 12 of the ARA provides a list of things that are to be taken into account, including the effects of the proposal on the environment, groundwater, surface water, and so forth. So those are the kinds of things that should be looked at under the ARA. So here's the basic information that you need if you intend to submit comments on the concurrent review of the ARA. And as I indicated on the last bullet point, the overall objective here of the Ontario government is to reduce burdens for business while maintaining strong protection for the environment and managing impacts to communities. I guess your position on this objective really depends on whether you believe that regulatory controls on pits and quarries really represent red tape or represent a burden to industry. In my view and in my experience, aggregate operations are generally not small, they're not benign, they're not interim land uses. Instead, they are environmentally significant, physically intrusive land uses that can and do cause adverse impacts both on-site and off-site. And so in my view, regulatory controls that are in place now are not red tape. They are essential and necessary to safeguard private and public interests. So I don't accept the premise that a lot of the things that we have in the RA is simply red tape. I think they should need to be maintained, if not enhanced. So, as I indicated in the first bullet point, the ministry is proposing both changes to the ARA and changes to the ARA regulation. But a lot of these proposals are only described in a broad or conceptual manner. I've seen no actual legislative text that is being proposed, and that's a bit of a problem because the devil will be in the details. It's hard to provide any meaningful comment or feedback unless we had those kinds of details so we can see precisely what's being proposed. And unfortunately, to my knowledge, that kind of information has not been disclosed for the purposes of this consultation. But here's a couple of changes that, again, caught my eye. I would say the first one is kind of both interesting but ambiguous. The M&R is proposing to change the Act in order to strengthen protection of water resources by creating a more robust process for existing operators that want to expand to extract aggregate within the water table, allowing for increased public engagement. Well, you know, if you break that down into its constituent elements, there are a lot of different parts. They're like, exactly how are they going to strengthen water protection? What does a more robust process look like? What is increased public engagement? Those are important implementation details that I haven't seen yet, so it's hard to respond. The second paragraph deals with a proposal that the depth of extraction of pits and quarries is managed under the ARA, and they would oust the application of so-called duplicative municipal zoning bylaws that deal with the same matter. You know, I have to say I'm not really clear on the basis, the empirical basis for this particular change. I've done my fair share of pits and quarries cases over the last 30 years at CELA, and I would say typically the elevation of lifts and the elevation of the final quarry floor is almost always dealt with in detail in documentation and site plans under the ARA. So I'm not really sure what problem this is actually solving across the province. Then we'll move to the next one, haul routes. The government's proposing some ARA changes in relation to haulage of aggregate. I won't go into this in any particular detail, but I would suspect that this change may be of a concern to host municipalities, or more importantly, their taxpayers, in situations where dump trucks or other quarry-related traffic is causing wear and tear to local roads, or where road improvements or upgrades are necessary. That's all I'll say about that one. And then finally, as I mentioned a few moments ago, the government is proposing certain changes to the general regulation under the ARA. And again, I've seen no proposed regulatory text. I haven't seen a regulatory impact statement from the MNRF, which again makes it hard to analyze and respond to these general proposals. The ones that caught my eye include item A, enhanced reporting by operators on rehab activities. Well, that's great to have more self-reporting by operators. Well, what about enforcement? What about MNRF enforcement of existing rehabilitation requirements? I think that would be a higher priority. Item B, allowing operators to self-file changes to site plans for certain routine activities subject to conditions set out in regulation. Well, what routine activities do they have in mind? What are the conditions that are going to be set out? Again, questions in my mind. The same concern exists in relation to item C, allow some low-risk activities to occur without a license if conditions in the regulation are followed. Well, again, what kind of low-risk activities are we talking about, and what are the conditions that are going to be specified in regulation? So again, as I say, the devil's in the details. Maybe that information will be revealed down the road in the fullness of time, but right now the clock is ticking on consultation. It's hard to respond to some of these ideas in any particular way. So let me stop right there. I've covered a lot of territory in a short amount of time. We're going to open it up for a few questions and comments. I would remind you that you're supposed to use the Q&A button to submit questions, and we'll try our best to answer them now or after Anna's presentation.
All right, thank you, Rick. So we have quite the pile of questions, and I'm just looking through to see which are best to leave until the end of our session and which are best to share now. So I'm going to read a couple that are specific to, I think, the content you were speaking to. So we have a question here that asks, is it true that under the proposal for ARA, municipalities can't put in road use agreements?
Well, I think I dealt with that in the last slide. I think the MNRF position is that municipalities and proponents are always free to negotiate voluntary agreements, but it can't be forced upon proponents as a condition of the ARA license.
Okay. Then another question, there's a question outstanding with OSSGA and perhaps MNRF about whether the Glassbell decision more significantly implicates or authorizes increased municipal decision-making about aggregate planning and operations.
I would prefer not to answer that. Thank you very much for the question. That's one that would require a little bit of legal research and a legal opinion. I don't think I'm prepared to do that in this webinar, but I would invite the questioner to contact us after the webinar is concluded.
Perfect. Okay. Thanks, Rick. All right, next question. One thing I found as reading through both the PPS and ARA changes is that with depth of extraction clarification prohibiting vertical zoning, all the peer review costs would be on the municipality as part of an objection to a major site plan amendment rather than recovered from the proponent as part of the zoning change application to go below water table. Is that a correct interpretation?
I would share that concern, and I'm sure municipalities would have that as well. And I would expand that concern that where there's a proposed extraction before the water table, the municipality itself is not, it's not just the municipality that's going to be doing peer review costs of the Hydro G reports that are going to be generated. I would say local citizens and environmental groups and others will probably incur the same costs. And again, that's going to be something that they're going to bear themselves, which is unfortunate, but that seems to be the cost of objection. You have to be prepared to put some money and some time into it with little or no chance of recovery.
Okay. Two more questions I will read now, and then we'll save the rest for the end so we have enough time for Anna's presentation as well. Question here that asks, do the proposed changes to the PPS affect the requirements under the Clean Water Act or Oak Ridges Marine Conservation Plan Act?
Well, I'll deal first with the Clean Water Act, and maybe then once Anastasia has gone through her presentation on the other aspects of the PPS, including increasing the housing supply and its mix. I think that's for a better spot maybe to answer the Oak Ridges Marine question. But in terms of Clean Water Act, there are no direct proposals in the PPS 2019 or the ARA changes that would directly change what's happening on the ground in the Clean Water Act. The problem that I see, and I'm on a source protection committee under the Clean Water Act, and had some involvement in the Walker inquiry as well. Quarries really only get subject to the mandatory tools under the Clean Water Act if they happen to be located in or near a municipal water supply, either groundwater or surface water. Now, some quarries, of course, maybe in a highly vulnerable aquifer or a significant groundwater recharge area for the purposes of the Clean Water Act and the source protection plans. But a lot of those tools aren't really that binding or that effective as compared to the tools that would be available if they were located in an IPZ or a wellhead protection area. So the short answer is there's no direct changes, but it really depends on the ground where the quarry is and whether it does have any impact on the municipal water system.
Okay, Great. One last question, then we'll turn it over to Anna. Will municipalities be allowed to protect wetlands more if they choose to, or is it possible that there would be a prohibition placed on municipal authorities not to be able to do so?
Well, again, it depends whether the wetland is significant and where it is in the land base. You know, take a hypothetical example. If we have what we know to be a provincially significant wetland in one of the Southern Ontario ecoregions, municipalities have to protect them. That is mandatory. The concern is, what about the large numbers of wetlands that remain unevaluated even at this late stage? They may well be significant in terms of their features and functions, but unless they are actually assessed, they don't get that protection of being a PSW. So that's why I'm a little bit concerned that the PPS appears to make it discretionary for local municipalities to go out and find and protect these things. It doesn't prohibit them from doing it, but doesn't really incentivize them to do it either. And that's, I think, the concern.
Okay. All right. Thank you, Rick. Let's turn it over to Anna, and we'll have another Q&A at the end of her presentation.
Thank you. I'm going to talk briefly about three of the other categories that Rick mentioned off the top that are part of the things that the government have raised and would like to have our opinions on. And as Rick did, what you'll see are a number of the changes, but not every single change, not just some of the ones that are top of mind or rose to the top when we were doing our review. On this slide, this is just taken directly from the Environmental Registry Notice. So these are the reasons behind the proposed changes to the housing mix and supply policies. I'm going to, again, pick on a few of them to bring them to your attention and talk about them a little bit more. One thing that I want to just note, and Rick mentioned this in passing, there were references. Here there's a reference to updating provincial guidance to support land budgeting, the projection methodology. There's a number of references to guidance and new guidance and evolving policies related to, in particular, the flood management, the flood advisor, and the recommendations that might be coming forward from that process. All of this additional information, things that are continuing to evolve and change, this does create quite a bit of uncertainty in how the policies are going to land and how they're going to be implemented and interpreted. And this runs counter to one of the stated objectives of ensuring that there is more certainty and clarity. So this evolving additional information that we don't currently have access to, and we're not sure when we're going to have access to this kind of additional information. We'll keep watching for it and we'll comment as it goes along, but it does create this sort of lots of moving pieces, and trying to understand them all is one of the concerns that I see. One of the changes that I'll bring to your attention is the change to the land supply. The planning time horizon proposed to increase from 20 years to 25 years, and the housing land supply requirement increasing from 10 to 12 years. The underlying rationale and the rationale that we saw during the housing supply strategy consultations is that there is a lack of service land available for development, and this is not supported with empirical data, particularly as Canadian Environmental Law Association and many others have highlighted. There's a report from the Nectus Foundation that indicates there is quite a large amount of unbuilt supply of lands, and so extending the time horizon out even further with our thinking and designing and planning for communities changing over these vast periods of time, it doesn't seem like it's a wise way to move ourselves forward in terms of planning our communities. The Second thing is the terms market-based and market demand are appearing at various places in the draft policies without supporting definitions or explanations. And this way of describing residential types, of setting conditions for when we're expanding and settlement boundary area at a time of a comprehensive review, describing the housing options, describing our long-term prosperity, using these terms without a clear understanding or a deeper understanding of what is meant by them and how they're to be used and interpreted. I have some concerns that this, looking at the market as it has been in the past, has it trended in the past, is not actually consistent with our future vision for what we want our communities to look like in the future, where they're compact and complete and climate resilient. And that's one of the things that we see the changes in the policies and have some concerns around how this shift might impact how the communities are planned and designed, how our communities are planned and designed. And picking up on Rick's comment around the use of the term impacts of a changing climate is very much focused, and importantly, focused on our adaptation to how we're feeling the effects of climate change through water, and do want to see, and I'll talk about some of those good policies that are being proposed. We want to see that kind of inclusion in our planning. We also want to be designing our communities to minimize our greenhouse gas emissions, and the shift from considering climate change, or we would maybe even want to go further in terms of planning for climate resiliency, includes both mitigating, reducing our greenhouse gases by our community design, as well as planning for adaptation, and that's something that I've flagged for everybody in their consideration. The next area to talk about is the expansion of settlement boundary areas. One of the alarming items in terms of direction, when there's directive language about what a planning authority shall do, there were two instances here in the settlement area boundaries expansion, and also in intensification and redevelopment, where there was a directive to shall apply the wise use and management of resources and the protecting public health and safety policies, and those are being proposed to be removed. And that is of concern, as we want to be, in the future climate resilient. We need to be planning our communities in a way that that takes these things into account and actually promotes the use of green infrastructure and natural heritage as a way to help protect us and adapt to climate change. There's a new, in the place of this directive around sections 2 and 3, there's a new level of flexibility within the undertaking of comprehensive review, that the assessment would correspond with complexity and scale of the proposed settlement boundary expansion or development proposal. Adding this in, again, without knowing what they're thinking in terms of why do you need this flexibility in the types of assessments that are done with a comprehensive review, that should be something that is standardized or explained in further detail. And then the last one, of particular concern or particularly alarming, is that there is a proposal to add a new notwithstanding policy that actually would permit changes to settlement boundary areas outside of comprehensive review. And if our focus is on planning complete compact communities, then this should be done in a rigorous way at the time of a comprehensive review, and CELA isn't supportive of those kinds of changes. And then the last thing I'll bring to your attention under this section is the change, again, in more permissive language from something that was more directive in the current provincial policy statement. When there's development, there's going to be development in designated growth areas. That new development currently is directed to shall have a compact form, whereas in the proposal for 2019, it would be changed to more permissive language, should have a compact form. And again, if our vision of achieving community development that is compact, complete, and climate resilient, then we need to be making sure that we're maintaining or strengthening those kinds of policy directions. The second area that I'm going to discuss from the ministry's proposal is the category of reducing barriers and costs. And again, the rationale that is taken directly from the environmental registry notice includes a number of things. There's a couple of these, this goal that the government is trying to achieve that relate to fast-tracking development and streamlining development proposals, reducing regulatory burden. As Rick has already said, it's a position of the Canadian Environmental Law Association, and I'm sure positioned for many, many people in Ontario, that ensuring that we are protecting drinking water, protecting natural heritage, endangered species, and other aspects of the public interest are not regulatory burden. They are some of the things that we have a public interest in and want to protect into the future. We are not opposed to fast-tracking and streamlining development so long as it's achieving the vision. And I've often heard my colleague Rick say we want to get to yes faster for development that's consistent with our vision. We want to get to no faster for development that's not. And the way that these policies read together, the proposals read together, have some concerns that we're not actually moving it in that direction. Just one thing to bring to your attention, I'll just pop back here for a sec. You'll note that one of the rationales here that there be ground-mounted solar facilities that are actually directed away from prime agriculture and especially crop areas. And then in the definition of on-farm diversified uses, it includes ground-mounted solar facilities are permitted in these areas. And if it's intended to direct it away from that, then presumably it's adding this kind of aspect to a definition is not actually consistent with what the government is trying to achieve. And in our whirlwind review of the different categories of the Provincial Policy Statement review, the last area that I'm going to speak to today, supporting rural, northern, and Indigenous communities. Again, from the Environmental Registry Notice, what is to be achieved is clarifying some barriers to servicing policies that I'll talk about, enhancing municipal engagement with Indigenous communities. And one thing I'm going to discuss that actually was one of the earlier points around stormwater management, around environmental protection. I'm going to talk about that briefly as well. If you've had an opportunity to read through, I think you'll find that there is a new description in the vision for land use planning for Ontario through the Provincial Policy Statement that describes the relationship between Indigenous communities and lands and recognizes the constitutional protection of Indigenous environmental, Indigenous Aboriginal rights and treaty rights, and as well as a more prescriptive mechanism within the coordination policies that municipalities, rather than what the language currently says is that they're encouraged to coordinate with Indigenous communities, there will be more directive language that they shall engage with Indigenous communities. And I see these as strengthening the provincial policy statement. I assume and hope that the government has worked with Indigenous communities in consulting them, that this meets their needs and is consistent with what they would like to see in the policy. Happy to see those changes. And similarly, on the stormwater policy, the policy proposals indicate that stormwater management planning will be integrated with other water services, something that Canadian Environmental Law Association and many others have been saying for a long time. It's important to plan sewage, water, wastewater, sewage, and drinking water and stormwater systems as one water altogether. Planning for those has the potential to be very effective. It will be responsive to impacts of a changing climate and include water conservation and efficiency. All of these are great additions to the provincial policy statement. And one small concern around a change to the risks that would be when we're looking at risks in stormwater management planning. It currently, under the 2014 provincial policy statement, says that those changes, if you're doing stormwater management planning, you're to not increase risks, and that change slight weakening to mitigate risks. And then finally, in addition to aggregates, as Rick has mentioned, one of the very alarming changes to the provincial policy statement are in what has been referred to as the municipal servicing hierarchy. That the intention is that we're planning our water and our drinking water and wastewater services to have them hooked up to municipal services, have municipal servicing, have it done in a very efficient manner, have lots of redevelopment and compact development, so those water services are actually inexpensive. And there are several changes proposed that would allow much greater flexibility in terms of using private and on-site services. The concern, among other things, is how will we ensure that the commitments to eventually having everybody protected by drinking water source protection, which doesn't extend to private services and small communal services, only to our municipal services so far. Concerns about how we're doing our planning and whether or not it remains within our vision. These additional flexibility without very directive combinations of all the other policies together is something that we are particularly concerned about. And now we'll head back to some questions, April.
Great, thank you, Anna. Well, while you were talking, Rick has been flying through our questions in the Q&A box, so I think a lot of questions have been answered. Rick, if you want to unmute, were there any questions that you read as you were going through that you think it would benefit everyone on the phone and everyone listening who might not be reading the Q&A to hear?
Well, unfortunately, they no longer appear before me.
Oh, you can grab them in the answered tab if you look just to the right of the open tab, Rick.
Okay, well, but what I was going to say, that this whole issue actually did come up. Somebody posted a question asking whether or not the question and answers themselves will be available to webinar participants after the webinar. And you'll see I deferred to you, and I have no idea. But it might be a good idea. I've banged out some fairly terse answers to some really good questions. So for what they're worth, it might be useful to make them available to people.
Sure. Yeah. No, I've said we will make sure to do that. So I'm scrolling through some of the questions that were posed. Rick, maybe I'll read a couple and then you can let me know if they make sense to answer. How does the PPS and/or the ARA interact with the proposed excess soil policy that's currently being drawn up? Was one question that was asked.
Yeah, I wish I could access my answer.
Would you like me
Well, yeah, you can read my answer, and then I'll embellish it if I have to. I don't know. Did we lose April?
She may just be looking for it.
No, can you hear me okay?
Oh,
Yeah.
we did lose you for a sec. Go ahead again.
Not funny. Okay. One would hope that there is consistency, but unclear to me at this time. No problem with reusing clean or inert fill, provided that it is clean and inert, as opposed to sending to disposal.
Yeah, so the Ministry of Environment, Conservation and Parks has been overhauling its excess soil management regime for quite some time. And the concern is, construction debris or contaminated soils that do pose a risk shouldn't be reused on site or stockpiled. They should be, put somewhere that'll be, safe and not provide any risk to, nearby people or groundwater, surface water, whatever. On the other hand, soil, clean earth, those are valuable resources that can and should be reused where possible. My concern is the testing protocol, who's, taking the samples, are the, analytical results reliable, who's making the determination if it's clean or not. To my mind, those are still residual questions. I have support for the overall policy objective, which is to make sure that clean earth or other materials are reused where possible, but sometimes we've run into problems on the ground. So hopefully there won't be a disconnect between, what this new abbreviated policy says in the PPS and what the on the ground reality is going to be once we see full implementation of the new MOE, Ministry of Environment, Conservation and Parks regime.
Okay, thank you. A couple new questions that have popped up, so I'll share a couple of these. We have a few more minutes. Curious as to why private systems are proposed and emphasized. Is this in relation to rural lots and private wells, which are common outside of municipal control? And I think that was a question based on your last couple of slides.
Yeah, I think it's within the understanding that sometimes there needs to be additional flexibility for how those services are provided based on where the location of the development is. And there's no, from the perspective of trying to adhere to this hierarchy that we try to, connect people to municipal services first and foremost and focus our development in those kinds of areas in rural communities, that might not be possible, and there needs to be some flexibility. So if that's the rationale behind it, then let's make sure that that it becomes the exception and not the rule for how the development is carried forward.
Okay, and then there was another clarification on that same topic, just wanting to make sure I interpreted correctly that communal sewer or water services won't be covered under source water protection plans.
Well, Rick, you can jump in on this as well if you want. The way that source water protection has rolled out in the province so far is that it only has covered the larger municipal systems and hasn't been extended to private systems, to the small communal systems. And so building more of them and not yet having source water protection cover everybody in the province could lead to a concern there.
Yeah, I'll just add to that very briefly. Anastasia is right. The first round of source protection planning did a fairly good job at identifying and protecting sources of municipal drinking water. So if you're one of the millions of people in Ontario that consume water from a municipal system, you're well protected. But if you're on a private communal system or a private domestic well, you're not covered by the Clean Water Act, and that needs to be the focus of the next round of source protection planning in this province. I know my source protection committee and the Environmental Commissioner of Ontario, other source protection committees, the Auditor General of Ontario have all identified this gap as a problem that needs to be addressed. We need to bring, communal systems in small hamlets and villages into the protective net or protective framework of the Clean Water Act, but so far that hasn't been the case. Although we at CELA have been trying for years to extend the scope and the reach of source protection planning.
Okay, and we do have a few more questions still in here, but I'm conscious of time. I want to make sure we get to next steps. So we can keep answering those questions in writing, and we will circulate those along with the recording and the slide deck. But Anna, did you want to do the next steps?
Sure. Sure. So what's next? Please give us your feedback. There will be an evaluation survey. We'd love to hear what you thought of this webinar. And if you have ideas about future webinars, we're testing the webinar function on Zoom for a few months. So if you have those ideas in mind, please send them our way. And any other questions, ideas, concerns about the Provincial Policy Statement review, you can send them to me. We're taking everything into account as we develop our submission, and we will be making the recording of this webinar, the slide deck separately as well, if people just want the slide deck, a summary document that we promised for this webinar, but we will be doing that in the next couple of days, and then our final submission. We make all of our materials available on our website, so those will come in due course. And most importantly, please do participate. We're very excited to see so many people interested in the Provincial Policy Statement review. Make your voices heard through by emailing, by posting the notes under the environmental registry notices, or mailing them. Those details are in the slide deck, and so you'll get them when we send out the package of response to your participation today. And really, really appreciate you taking the time, and thanks so much for your attention, and we'll be in touch again in the future.
Thank you, Anna. And I'll just note there was a question about whether it's better to submit comments by email versus through the registry, and the answer was that both are equally good. There's a paper trail in both cases, so either option. Well, thank you very much, everyone. We're at 2 o'clock, very much on time. We will get all of those materials to you, as Anna said, and thanks for your time today.
Great, thank you.
Bye, everyone.